All right. Welcome, everyone. Yet another edition of International Law in the Global South, the research seminar series. And we're extremely pleased to have with us today to present her work, Carol Lichuma, who is a lecturer. That's what it's called over there, not professor, lecturer at the Riara University in Nairobi, Kenya, where I've had the pleasure of giving a lecture myself, partners in some research that we do here. Carol is a lecturer there. She graduated from the University of Nairobi in Kenya, the same country, in, well, she dates herself, 2010, with LLB. She received the Hamilton, Harrison, and Matthews Prize for the best third-year student at the time. Thereafter, she proceeded to NYU, New York University. She obtained her LLM, a master's in law. There was a dean graduate scholar there. She graduated in 2012 from NYU. She's also a certified public accountant. Talk about many parts, and teaches all manner, as you can imagine, of subjects, ranging from public procurement law to evidence to accounting to international law to insolvency law to commercial law and corporate law, as well as human rights law. Her key areas, though, of academic research are public international law, especially economic and social rights law, international human rights law, and comparative constitutional law. In 2014, she was selected as the Irma de Vattel Scholar at the famous, I must say, Hague Academy of International Law, the summer school program. She also has a diploma in economic and social rights from the Abo Academy University in Turku in Finland. And just recently, in 2017, was selected as one of only 10 participants to present a paper at the highly prestigious Stanford Law School and University of Pennsylvania's International Junior Faculty Forum. So please, ladies and gentlemen, join me in giving a very warm Osgoode welcome to Carol.
Okay, so thank you for that very kind introduction, Prof, and for extending this invite for me to be here. Thank you all for showing up for the talk today. I hope you'll enjoy the discussion. So I figure what I'll do is that I'll first kind of outline the paper, like what I have in mind, and as far as the paper is concerned, maybe 30 to 40 minutes tops, and then we can engage in a discussion because the paper is as yet unpublished, so it's still a work in progress, which means this is probably more useful for me than it is for you. I'm going to get a lot of feedback in as far as to how to further improve my paper. So as Prof mentioned, this is actually the paper that I presented at the International Junior Faculty Forum in September of last year. So I'm still working on it in hopes that I'll be able to have a final draft ready in the next couple of months so that I can get it published. Okay, so I think I'll jump straight into it because he's already given enough of an introduction. The only thing he didn't mention is that I come from a country that has 2 presidents, FYI. Okay, so I'm kind of ashamed to admit that I was a late bloomer in as far as Twailing is actually concerned. Like, I didn't know about Twail until very, very recently. Unfortunately for me, the way our LLB was taught, the system in Kenya is very structured, like curriculum-wise. So there's no room for critical thought in this sort of way. So I only discovered Twail probably in 2014, 2015. And then when Prof was in Nairobi visiting and talking about Twail within the context of international criminal law, it really kind of got me interested. So then I thought, is there a way to combine this new area of interest with an old love of mine, which is economic and social rights? I'm trying to establish myself, as an academic thinker in that particular area. So then from these kinds of internal monologues, I got the idea to come up with a paper, so Twailing the minimum core of economic and social rights. So then the paper is divided into about 4 parts. In the first part, I try to analyze Twail, not in so much detail, but just within the context of its potential application in the human rights sphere, the international human rights sphere. Then in the second part, I interrogate the minimum core concept itself. And I restrict my analysis to the minimum core as utilized by the Committee on Economic and Social Rights. So I don't go into regional and national uses of the concept itself. Then now in part 3 of the paper, I try to do, so now perhaps the crux of the paper, right? So I try to look at the minimum core concept and criticize it from a Twail perspective. And then finally, I end up with trying to offer a reconceptualized minimum core concept that is alive to this, Twail critique that I have given all through the paper. So I'll kind of just take you through my thinking in as far as the 4 key parts of the paper are actually concerned. And then I guess at the end, we can have the dialogue that I've mentioned, a conversation as to what you think about the research itself. So, of course, because you are in Osgoode, in the presence of a Twail sensei, if we can call him that, you probably know what Twail is all about. So in the paper, I don't go into so much detail about, Twail and the origins and the different, ways that people have come at Twail. But I do try to focus on discussions on Twail within the human rights context only. So then, of course, the key thing about Twail, the thing that unites Twailers, as they are called, is the fact that they're very concerned about international law and transforming international law to be very sensitive to concerns of third world states, or states that have identified or self-identified as third world states. So then, within the context of this particular discussion, I zoom in on the question of universality of human rights principles, and argue that from the perspective of Twail, at least, the minimum cause enunciated by the Committee on Economic and Social Rights should be universally applicable, but there are problems with having the minimum core being universally applicable, and especially in a situation where you have differentials between the different countries that are state parties of the Covenant on Economic and Social Rights. So then, thinking about universality in this sort of way, universality is a big thing in international law. And depending on the perspective that you actually come from, my argument is that some people think about universality and immediately think, oh, equality. So it's a good thing, right? So we should cherish, universality. We should be happy that we do have universal legal norms in this sort of way. But then some people think about universality and they think, no, hegemony. And then that becomes problematic, because then you will see that if you have universally applicable norms, then there could be problems. And in this way, we need to resist universality or attempts at having universal norms. So then, for the limited purposes of this discussion on, the minimum core concept, I argue that sometimes universality can be problematic, because universality appeals to third world countries when they're signing on to, these kind of human rights instruments. So then you're attracted by the thought that, oh, there'll be a universally applicable norm. But then when you do get in it, you realize that international law has actually used universality to lure you into something that could actually be oppressive. So then, which is now the key argument that I try to pursue later on in the paper. So then in the the final part of the first part of the paper, I basically make this argument that many people have talked about, the Twail from different perspectives and all that. And people who have talked about Twail within the context of human rights have kind of focused on very specific issues, like the effect of, colonialism on the cash crop economy or on food production in third world countries and so on and so forth. But I kind of move away from all that. And I want to restrict my analysis only to the minimum core as it has been elaborated upon by the committee. So then in part 2, I go on to try and think about the concept. And I actually titled my part 2 of the paper and say that this is a concept that has maximum dissemination, but potentially it has minimum clarity. So then I try to interrogate, perhaps a little superficially in the first draft of my paper, the use of the minimum core concept. So then, of course, the committee first came up with the minimum core concept in at least, kind of put it down in writing in 1919, their general comment on the nature of state parties' obligations. So then, of course, with economic and social rights, we always have the twin progressive realization, but at the same time, there are those obligations that are of immediate effect, which is where the minimum core concept actually comes in. So then what I do in this part of the paper is I actually try to interrogate since 1990, how and when has the committee used this minimum core concept? So then I go into the general comments, the various general comments for the different rights under the International Covenant. So, the minimum core in as far as the right to food is concerned. So general comment number 14, or the minimum core in as far as the right to health is concerned, and so on and so forth. And you notice that for all of them, the committee, they talk about the minimum core. It's very important. It's one of the key things in the International Covenant on Economic and Social Rights. But they don't really, they skirt over the issue, at least in my analysis. They skirt around the analysis of what exactly is the minimum core and how exactly does it apply, and especially within the context of unequally or dissimilarly placed states. So after I look at the various general comments, I now go into the state party reports. So I try to do a very shallow analysis of, some of the concluding observations that the Committee on Economic and Social Rights has given within the context of the state party reports to the Covenant. And I highlight examples such as, the 2008 concluding observations given to the government of Kenya, where the committee says that, look, you need to make sure that you comply with the minimum core requirements in this particular area. And I flag various other examples, now kind of both in the, let's say, third world countries and non-third world countries. And I basically show that, or attempt to show that, the committee seems to use this minimum core concept universally. Like they don't distinguish between, a country in the global south or a country in the global north, as it were. If they're going to give in the concluding observations, recommendations within the context of, you need to have the minimum core actually being fulfilled, then they'll do it almost evenly in this sort of way. So then something else that I mentioned in as far as the part 2 is concerned is the fact that since the committee hasn't done a good job of, at least in my opinion, elaborating on exactly what the minimum core entails, exactly how it should be implemented in practice, and especially in light of the resource differentials between countries, I now try to look at academic work that I thought did a good job of trying to go into the details of what the minimum core concept is actually all about. And I rely very heavily on Catherine Young's work, the analysis of the minimum core in trying to give that concept some content. And in that paper, which is, I think, very seminal in the field of ESR, Young basically argues a number of things. She says that the minimum core is problematic, and many people agree with the fact that the minimum core concept is problematic, as espoused, by the Committee on Economic and Social Rights. Some people even say that let's do away with the minimum core completely, but then I say no, and agreeing with Young that the minimum core concept is still useful. It may be problematic in as far as its application in practice, but certainly this doesn't mean that we should do away with the concept entirely. So then Young basically in her paper thought about ways to imbue the minimum core concept with content. So she makes 3 arguments. She says that, okay, let's think about the minimum core concept as normative essence. So then she says that if we think about the essence of the right, it may help us to figure out what the minimum core of the right should actually be. Then she thinks about 2 different things within the context of the essence of the right, and she says that we could either use a needs-based approach or a value-based approach, so that we say that, okay, rights, people have basic needs, and so long as the basic needs have been fulfilled, then we could say that the minimum core of the particular right in question has actually been fulfilled. But then in thinking, so then in this part of the discussion, what I do is that I now come and make the argument like to try and use a twin lens to analyze what Young suggests. So that I say that if you potentially want to argue that the minimum core concept should be needs-based in this sort of way, then you'd immediately have a problem from the TWIL perspective. And the problem that I outline is the fact that potentially, if you think about the minimum core as being a needs-based core, what is basic need, or what a basic need is, varies from one society to another. So then if you say that we have basic needs and you don't go into the details of the variations, it could immediately make it easier for some states to look as though they've met their obligations in as far as the minimum core is concerned, in as far as provision of the basic needs, and for some states to look like they have not been able to do so. So that an example that I use in the paper, I give the example of the minimum core within the context of discussions on right to food. And I compare Kenya and France, for example, and I say that if you think about Kenya and France, if you think about the resource potential of these two different countries, and if you think about one of the core obligations within the context of right to food being alleviation of hunger, then it may be easier on balance to say that, well, a country like France will be able to meet that minimum core, and then a country like Kenya would not be able to meet that particular minimum core. So then, for this reason, the needs-based analysis becomes a little problematic from a TWIL gaze. So then Young also argues that, okay, if the needs-based way of thinking about the minimum core is problematic, how about we use a value-based core? So let's use values like human dignity, right? So that we can be able to say that the minimum core is only met when values in a particular culture, in a particular society have actually been satisfied. And I think from a TWIL perspective, this would be something more palatable, because if you think about a value-based core, something that Amartya Sen has spoken about also in his work, then it means that you necessarily have to go into the details of what is suitable in one society as compared to another. So then that would mean that a resource-rich country would not be able to get away with saying that, oh, we've met our minimum core just because they've given the very basic, right? They'd have to go further and show that, okay, according to our society, this is what a value-based core would mean, and this is how we have actually been able to deliver on that. Then the other thing that Young says is, okay, if the normative essence of the core is a bit difficult to kind of conceptualize, how about we think about the minimum core as being obligations? So basically thinking about the obligations that need to be fulfilled before we can say that the minimum core has actually been met in a particular context. So then there are many ways to think about obligations within the context of economic and social rights, and the committee has been very vocal on the various ways. So I use the example of obligations of conduct and obligations of result, for instance, and I say that if you think about the minimum core concept as being all about obligations necessary to that a state has to meet in order to be said to actually have complied with the minimum core concept requirement, then depending on whether you use obligations of conduct or result, from a TWIL perspective, you may sense some tension. So that, for instance, if we say that we are looking at obligations of result, then you see from a TWIL perspective, you immediately have the results that you expect, and then whatever indicator is being used depending on the right in question to assess whether certain obligations have actually been met by the state in question, we could have a problem, because for a country in the developing world, so third world countries as I call them there, if we're only looking at the results and the results being tied to resource availability, then again it may be difficult to say, or it may be easy actually to say that these people are not complying, they're not meeting the minimum core obligations of the covenant. But then, on the other hand, if we decide to use now obligations of conduct, I say, at least from a TWIL perspective, this becomes more acceptable, because when you think about obligations of conduct, you don't just jump straight to the end and ask what has been done in terms of 1, 2, 3 indicators. Instead, you have to actually go through the process of looking at the conduct of the government or the state in question in as far as provision of the right is concerned, which opens the door up for a more in-depth analysis that allows for differentials between the various states to actually be factored into the analysis. Then the third way that Young thinks about the minimum core concept is that if you think about the minimum core concept as consensus, right? So which is what some people argue, that the committee didn't initially specify what exactly the minimum core concept is, but and one of the former chairpersons of the Committee on Economic and Social Rights says that, okay, we could do a sort of positivist inquiry to try and figure out what the minimum core concept actually is. And that means let's look at what the state parties agree to be the minimum core, then that's what will become the minimum core. So that's the consensus approach to trying to figure out the content of the minimum core. But then again, from a Twill perspective, I say, no, I have a problem with that, because whose consensus is going to count, right? Like if you think about consensus within the context of international law, and international law in a situation where, you know, we have some countries that are dominant and others that are not, it means that sometimes consensus may not really be true consensus. So even within the context of analyzing the minimum core concept from this kind of angle, there could already be a sort of a Twill problem in this sort of way. So then my key argument becomes the fact that you can't have a universally, or suggest that you have a universally applicable norm in the claims of differently situated people, because this is going to be impossible and unfair. And as such, because of this kind of analysis, the current application of the minimum core concept, at least as espoused by the Committee on Economic and Social Rights, is actually going to be problematic. So that Twail always, and Twail, like the Twailers have actually been able to show that the problem with international law or international human rights law within the context of this particular discussion is that it tends to foster certain dichotomies, right? So you have the good West, you have the bad South. So we demonize the bad South, the third world, while making the West seem as though, they're the good guys in international law in this sort of way. So then my argument becomes that if we don't think about the minimum core and perhaps nuance it a little, right, within the context of its application, then we're actually going to just keep, we're going to kind of allow this Twail critique to come to life. Because if you have a context-blind minimum core, right, so the minimum core applies universally to both countries in the third world and countries that are not in the third world, then you may find that countries in the third world are unable to meet the minimum core, but countries in the first world are able to meet the minimum core, or at least appear to be able to meet the minimum core by virtue of the fact that they have more accessibility to resources. Maybe some of these countries are welfare states. So in as far as the minimum core that is undefined is concerned, then we'll have this kind of dichotomy in application. So then I asked the question in the paper that, and I try to go back and figure out why is it that when the committee came up with the minimum core concept in 1990, they were deliberately vague, at least according to me, right? Like they talk about this concept, they make it sound like it's so important, which it is, but then they deliberately skirt over the finer details of how the concept is actually going to apply. So I argue that within the context of saying that the minimum core applies, because the committee says that, yes, the minimum core applies within the context of interpretation of state obligations under the covenant. And they also mention that resource constraints will be factored into the analysis of whether a country has been able to comply with the minimum core or not. But then if you're talking about resource constraints, why not go the full 9 yards and also talk about resource abundance, right? Because there are countries that do have resource abundance. So that for these kinds of countries, how does the minimum core concept actually apply to them? Because my argument is that if we just look at the perspective of resource constraints and say that, okay, fine, you have to meet a particular minimum core of economic and social rights, the various social rights, and then you also go on and say that potentially when you're now, as a government, trying to say that you didn't meet the minimum core because you had resource constraints, that would be acceptable. For countries that had resource abundance, it immediately becomes very easy for them to say, well, we met the minimum core. So the fear is that there could be a loophole here that allows for escapist interpretations of the minimum core concept, meaning that countries that are more resource rich or countries in the global north will be able to assert that, hey, we've met the minimum core, so there's not so much more we need to do in as far as this is actually concerned. So then, in the paper itself, after I kind of give this analysis of how, the problem that I actually see in the current interpretation of the minimum core, I try to think of why exactly the committee would come up with the minimum core concept but not elaborate so much on its actual ambit. And for this, I turn to Kelsen and Hart, and I think about indeterminacy in law. And I say that, agreeing with them, that a certain measure of indeterminacy in law is usually important. It's almost inescapable if you think about it. And for instance, thinking about Hart's work on indeterminacy, he actually talks about the fact that whenever you think about the law, you're going to have the indeterminacy because of the open texture, the open language of law. And then he mentions the fact that you can expect to have like a core of certainty and a penumbra of doubt every time you're trying to interpret legal norms. And then borrowing on this, I try to argue that perhaps this is what the committee had in mind, right? Like when they came up with the concept, so that they wanted to deliberately make it indeterminate because international law hinges on the basis of consensus. So it's very likely that if the committee had from the very beginning been very strong-handed in as far as, this is the minimum core and this is how it's going to apply, maybe they would have scared away some states from actually signing on to the, the instrument in question. So then they're pussyfooting around the ambit of the minimum core concept in an attempt to get the consensus that is needed within the context of international law. So then I agree with this. I say that, okay, fine, indeterminacy is inescapable. But then you see there's intended indeterminacy and unintended indeterminacy. And my problem is the unintended indeterminacy, the fact that if we have the minimum core concept applying the way it currently is, my worry is that there's a loophole, a very real loophole there that exists for some countries to be perhaps held to a lower standard of account than others within the context of them meeting their obligations in the economic and social rights sphere. So then, sorry, is it okay? Can you? So we're going to pause.
If you want, I can give you just a
Okay.
handheld microphone.
Yeah.
It might be a little easier.
That's fine. Thank you.
Just give me a second to turn it on. Okay.
Are we good? Is it on? Oh, okay, good. So, yeah, so borrowing from Hart, I basically make an argument for having the minimum core being divided into two, so that we have a part of the minimum core that is very determinate, so the law being determinate in the core, as Hart has argued, and then having a part of the minimum core that is indeterminate, right? So a necessary flexibility device, if you think about it, taking into consideration the fact that you have all of these differentials between states that I have already actually mentioned. So then in the final part of my paper, what I do is that I try to potentially reconceive the minimum core. And I argue that instead of having just one universally or seemingly universally applicable minimum core, because that could result into the kind of tensions that I've already outlined earlier on in the paper, how about we have a minimum core that is two-tier, sort of imposes two tiers of obligations on states. And I make the argument that if you think about the minimum core in this perspective, like having a two-tier level of obligations, in the first tier, what I actually refer to as the absolute and non-derogable core, I basically argue that, so which is, to my thinking, what is currently there within the context of the minimum core and how it applies, I actually argue that what the CESCR, the committee, can actually do is that they could, in the first instance, have a standard that applies universally to all states, right? So this is the core of certainty, as Hart mentions elsewhere, so that this will be absolute and non-derogable. The content of the core itself could depend on the rights in question and could actually depend on, let's say, maybe indicators, right? Because if we use indicators in an attempt to kind of analyze whether certain rights have been met or not, then that could be a way to give these rights, to imbue them with content, as Catherine Young actually argues. And then in the second tier of obligations, so the subsequent level, we could now have a sliding scale so that depending on resource availability, the states have to justify additional action in as far as meeting the core obligations are actually concerned. So basically what I say there, that after the initial appraisal, a subsequent level of obligations could be imposed. And what I struggled with in the initial paper was, how would we be able to slide the scale exactly? Like in the paper, I even come up with a graph of sorts to try and show how I've conceptualized the scale. And my basic argument is that we could be able to use an indicator, whichever indicator that shows, resource differentials between the various states. And then the argument is that depending on where a particular state is on the scale that you're actually using in terms of whether they're resource rich or resource poor, as the case may actually be, you can be able to give them an additional level of obligations, distinct and separate from the initial absolute and non-derogable core that we have already mentioned. So that, for instance, I began by thinking about using GDP. I've since abandoned GDP because GDP is inherently problematic. But in the initial analysis, I'd mentioned that, okay, so if we were to imagine that we have two different countries, A and B, one from the third world, one from the global north. And then these two different countries have, of course, different GDPs, with one being, better to do and the other one not so much. Then this would mean that in the first instance, both country A and B have the same non-derogable obligation, the first year obligation. But then in the second instance, the country that has a higher level of resources as assessed by GDP or whichever other indicator could be used in that particular scenario, this country would have to justify additional action that they have taken in as far as meeting the obligations are actually concerned. So then in my thinking, what would happen if we had this kind of, let's say, dialogue? It would make it possible for resource-rich country to be held to a higher level of account than they currently are under the way the minimum core is utilized by the Committee on Economic and Social Rights. And then I finish up by saying that potentially, what would happen is that this wouldn't really upset how the Committee on Economic and Social Rights currently assesses whether states are actually meeting their obligations, right? Because usually under the covenant, you have the state parties' reports, and then the committee issues the concluding observations. So a sort of dialogue as to how far the state is in as far as meeting its obligations is actually concerned. So that now, if we were to have the minimum core analyzed in this sort of way, like two-tier obligations, like I've already mentioned, this would fit in perfectly with what already happens. So that at the point when a state party is issuing its report, the onus would actually be on them to justify what additional measures that they have taken in as far as meeting the minimum core, depending on availability of resources. And the beauty of what I suggest, or at least my thinking, is the fact that this doesn't have to be, a them versus us in the sense of global north versus global south. This kind of minimum core could also apply to acknowledge differences between different countries in the global south as well, because even for countries in the global south, they have differentials in resources, and perhaps this could actually impact how the various governments are expected to deliver on the promise of economic and social rights. So I think that's my paper in a nutshell.
Questions.
Yeah.
So we have time for questions, obviously. Who wants to, I don't want to say fire the first shot. Okay, sorry.
Thank you very much, Professor Caroline. I really like your paper, and I think I was just wondering, wow, I can imagine how much time you spent thinking about the minimum core concepts and even the committee's job on how they give these reports on different countries. I love your proposition you've made on the 2-tier, but I wanted to ask about the first tier, if that is not similar to the minimum core concept as it is now, because the minimum core concept now is saying all states should at least get to this floor, this non um, um, non-negotiable flaw when it comes to the realization of socioeconomic and economic sorry, economic and social and cultural rights. So is this your proposal for the first year, not just similar to the minimum core concept? That's the first one. And I know you mentioned that using GDP is also a problematic indicator. I was thinking if you thought using a country's budget might also be a possible indicator, because with globalization now, there's a lot of spending on security, and GDP actually is also, like, just like you said, it's very controversial. What other indicators do you think would be good for the second tier, like to gauge the second tier? And my final question, which is sorry. The reason why I'm asking so much is because my master's thesis was sort of around socioeconomic rights as well. My final question is, there is the statement somewhere in one of the general comments that resource-rich countries would assist third world countries or countries that are not very rich to achieve their minimum core, or push them towards achieving their minimum core. With these two-tier concepts you've proposed, what would you even say from a tool perspective about this obligation for rich states to support poorer states? I hate to use this description, but would it still have a place in your proposal? Thank you.
Okay, great. So your first question, yes, I suggest having a two-tier minimum core analysis. And you're actually right, and I think I mentioned that somewhere, that the first tier actually doesn't affect the minimum core as it currently is, because the way I see it, the way the committee is currently using the minimum core concept is universal, it's non-derogable, it's, it applies to everyone evenly in this sort of way. So the first tier maintains that. But then I say, in order to kind of deal with the 12 concerns that I've outlined earlier on in the paper, it's necessary to bring in this second tier. So that's a succinct analysis that you've actually pointed out. Now, for the indicator to use for purposes of assessing whether a state should be held to higher accounting as far as the minimum core is concerned, I must admit I'm still looking. There's so many different indicators, and every other day I come across something that could potentially work, so I'm still working through that. But GDP is inherently problematic, as you've actually mentioned, and thinking about the country's budget as a way to assess whether a country has resources or not, that would actually be viable, because a country's budget really shows a lot about whether they have resources or not. Because in economic and social rights, an argument is often made that, and when I was actually presenting this paper earlier on, someone said, but wait, are poor countries really poor, or do they lie they're poor? Lie they're poor in the sense that we have resources, but we divert them to things that we consider to be more important, national security, etc. So then, thinking about that kind of argument, it would actually be wise to look at the budget as a way of seeing whether a country has more resources or less resources, and then from there being able to kind of implement the second tier. I was thinking of using the Human Development Index as a potential indicator for this particular purpose, but I have to say that I'm still in the very early stages of thinking about how it would work, so I can't say more than that on that. And then, so the convention does actually talk about the fact that resource-rich countries, so when a country is trying to implement its obligations under the ICSCR, they actually expected to get assistance, right? And assistance could be assistance that technical or even resources from resource-rich countries and all that. But I think even within the context of the arguments that I've already mentioned, by saying that resource-rich countries will help the poorer countries to meet their obligations under the covenant, we are kind of reinforcing the stereotypes that have already been identified under Twailing, right? Like, these are the saviors. They're coming here to save the poorer countries. They're helping them to meet their obligations, because otherwise these poor countries that need saving would not be able to meet their obligations. It shouldn't be like that. Even these resource-rich countries, they need to own up to the fact that they have more resources and do more within the context of the economic and social rights field. So that's how I'd answer that.
Thank you so much for your talk. Actually, my question has sort of been answered because it was along the same lines as your final question, which is, have you considered the idea that states have a responsibility to cooperate and to assist? That it, especially considering that a lot of the rich states have built their riches through the exploitation of states in the global south, it seems particularly relevant to a Twailing approach to this idea. But since you've already addressed it, I don't know that I have any further comment or question on that issue. So I can continue to pass this.
Thank you. Okay.
In the first place, my apologies. So I'll be shooting my questions in the dark. I wasn't here in the beginning. Yes, but again, picking from the last sentences about the minimum core, I have problems actually when we talk about the minimum core, particularly in the context of, yes, yes. So I just wanted to, I missed some of the assumptions that foregrounded your ideas on the minimum core. But from most of the countries of the South, I'm not sure how that minimum core would be, what would be the threshold, especially in the context that much of the governance decisions on core decisions on issues like health actually are no longer made by these countries. They are made by external actors, like the World Bank, IMF. Those are the centers of power and decision making. And our countries really have very small space on which to make decisions. So I'm not sure how we can really talk about a minimum core and even look at already ideas such as GDP, Human Development indices, to try to formulate some kinds of ideas of how we can actually deal with the gaping inequalities in socioeconomic rights in the developing country. Secondly, in the current international trading regime, which is a take it or leave it. If you look at the WTO treaties, it's the only possible treaties ever have been made that a state, you either like it or you don't. If you don't sign. There are no reservations. So how would you calculate a minimum core in a context in which international rules are already crafted in a way that actually disadvantage the countries of the global south? Third and finally, how would you calculate the minimum core in the context that 1 unit of a currency in the West, whether it's a US dollar or a Canadian dollar, or I'll talk of a British pound with my own Uganda shillings. 1 unit is worth maybe 5,000 units. You see, 1 British pound is around 5,000 Ugandan shillings. But the British don't have the gold. The copper is in Uganda. All the other minerals are in Uganda. But that's the relationship. So how really do we begin to calculate the core, and how do we want our states really to have the obligations when they are actually not having any space left to decide on those very fundamental questions that affect whether my relatives in the village can have access to clean water, or they can be medicine in the hospital, or the roads can actually be tarmacs, or the schools can have relevant books. Thank you.
Okay, so thank you very much, Zachary, for your observations and questions. Of course, very excellent questions there. Now, your first question, you talk about how minimum is the minimum core concept, especially because governance decisions are made outside. And I think that's something that I actually kind of cover in my paper, because in part 2 of the paper, when I tried to interrogate the minimum core and how it's used, I mentioned the fact that this concept has been plagued with paradox, or by paradox, from its very inception. It's inherently problematic, which is why years later, I don't know how many years it is from 1990 when the committee first utilized the concept, we're still trying to find content that can imbue this concept with meaning. And I agree with you entirely that the way if we think about the concept, like where the concept comes from, in as far as, for instance, what Young argues, that we could think about the minimum core concept and try to get the content of the concept by thinking about consensus, right? Like, what do we agree is the minimum core of a particular right? And this is the question that I raised earlier on, where I say that whose consensus is it that actually goes towards determining that this is the minimum core? Certainly, to a large extent, I would argue that the consensus comes from outside parties. So you see, you're actually agreeing with what I'm saying, that there's a problem with the minimum core being utilized in this kind of situation, which is why I argue that there's a need to rethink how the minimum core actually operates, and to have the multiple levels, the 2 levels of analysis, in an attempt to make the concept more palatable or more acceptable in the third world milieu. And then for ITL, international trade law. So I actually scattered over that issue, and they deliberately did so because ITL is a minefield, I think, and I don't think I'm qualified to go into ITL and try to make the kind of analysis that I'm making here within the context of the minimum core concept. So then if you ask me that how do you calculate the minimum core if you have international law, international trade law that already disadvantages countries in the global south, I'll tell you I don't know. I'd need to think about it, which is a nice way of evading that particular question. And then the minimum core and foreign currency. So his third concern being the fact that, okay, so we're talking about the minimum core. We want to impose a minimum core of obligations on different states, but these different states are dissimilarly placed. And within the context of foreign currency analysis, for instance, you can be able to find that some countries are not entirely resource rich, but at least they appear to be richer because their currencies do better, and so on and so forth. That's absolutely acceptable. And I think that would go back to the point that she mentioned, that so then these countries like the UK or the US or these other resource rich countries you could mention that have perhaps a higher foreign currency than countries in the third world. Why is it the case? Are they actually resource rich, or is there a movement of resources from the third world countries to the first world countries that is detrimental to the third world countries and then beneficial to the first world countries? Absolutely. From a tool perspective, that would be a very viable argument to actually pursue. But then you see, the point that I'm trying to make is that even acknowledging, or perhaps putting that, shelving it for a little bit, if we think about 2 different countries, the example that we've used, you have Uganda and then you have the UK, and you're trying to assess the governments of both of these countries in order to see whether they've met their obligations in as far as the minimum core concept is actually concerned. We don't have to end at the point where we say that, okay, the UK currency is stronger, the Ugandan currency is weaker. We can hold the UK government to a higher standard because we expect better, since they have more resources at their disposal, regardless of where the resources have actually come from. And I think that if we have the 2-tier level of minimum core obligations, as I have actually suggested, where we use these indicators, and within this particular context, perhaps the foreign exchange rate becomes an indicator of sorts to show that one country is doing better than another, then we can be able to resolve the tension a little bit, or at least begin to resolve the tension in question by holding such countries to a higher standard.
Thank you once again, Professor Carroll. I personally find your work very interesting, and I can't wait to read the final draft. Thank you once more. Mine is not a question, but it's more of a concern, and which I want you, if it's possible, to throw more light on. It has to do with the sliding scale. That is the dual word, if you like, you were suggesting in your proposition. I am thinking, why would it be so? Why do we have to lower the bar for one country on account that they are not doing the right thing. I'll give you an example. In my home country where I come from, a particular state, the governor is busy using public funds to mold statues of people like Zuma that is not even doing well in his own country. It's not his private money. And these are funds or resources that could have been channeled towards meeting the minimum core content. But he is doing this. So by asking for this dichotomy, are we not, in a way, giving them license to say, okay, don't worry, your economy is not doing so well. You can go ahead and remain there. Don't grow. Don't be aspirational. And also, when we do that, how can that person grow? Why are they where they are? Till today, funds are being siphoned from a lot of countries in the South, and they're all taken to wherever, and nobody bothers to trace it. Can we not say, let's sit down, critically look at why we are where we are? How can we stop this? The other thing I have as a concern is, if this dualized or whatever you call it is implemented, what will it do to the international psyche of countries that are given the lower cadre? So in the, say in UN, and the countries, how do you expect the two countries to be on the same table and negotiate or discuss? Because already they have on their own taken that position that, well, we'll never do wells and we can never meet up. Thank you.
Ground in the paper, very much so. And I think I sound like a broken record all through the paper when I say I am not at all advocating for a shortcut for countries in the in the third world for them to be able to evade their obligations under the covenant by making an argument that, hey, we don't have resources. Not at all. So that how I figure it could work out in practice, one of the things that you actually mentioned is, if we use the minimum core, the sliding scale of obligations that I actually mentioned, will we be lowering the bar for one country because they're not doing well? So then are we giving them that excuse where they can be able to say that, hey, we don't have as much resources as this other country, so we shouldn't be held to that higher standard of account? And I actually don't think that this will be the case, because already within the context of the Covenant on Economic and Social Rights, there are mechanisms of accountability inbuilt where a state is required to meet the obligations subject to available resources. And in the discussion on available resources, then you see, you wouldn't be able to say that we don't have available resources if you actually have them, but they've been diverted to corrupt ventures or something of the sort that you've actually mentioned. So the committee would be hard pressed to believe that a country, whose government or whose certain members of government are misappropriating funds actually doesn't have resources, and therefore they're excused from not meeting the minimum core. And you see, the way I think about it and the way I mention the operation of the sliding scale is that it's not a them versus us, so that it's third world versus, first world, southern countries versus northern countries. Even within the context of southern countries, we're acknowledging the fact that there are genuine resource differentials between countries in the south, right? So South Africa could be doing better in terms of resource abundance as compared to a country like Uganda or a country like Tanzania. So then if we have a minimum core, the second part of the minimum core, the second tier of obligations that allows the state itself to justify the kind of actions that they've taken in light of the resources that they have, I think there's room for dialogue and interrogation so that we can actually only let off the hook, if at all we do, countries that genuinely lack resources in the given context, depending on whatever right is actually being analyzed. So I don't think asking for this kind of dichotomy is giving an escape route to anyone. Absolutely not. In fact, it may be kind of a double whammy in the sense that yes, for the resource-rich countries, they have an additional level of obligations, but even for countries that have been arguing that, we can't meet the obligations because we don't have resources, now they have to justify why, right? Because some of the examples that I use, I've used the Kenyan state reports sprinkled all through the paper, and the Kenyan government is notorious for that. They're always forever saying, we don't have resources, we don't have resources, and if you know anything about Kenya, corruption is up there, right? So then if we were to use or to think about the minimum core sliding scale in this sort of way, to be very difficult for the Kenyan government to argue, oh, we don't have resources, because then the committee could be able to go after them and say, but these are government resources that were diverted to this and the other venture. And then what will happen to the international psyche if we now have a situation where it appears that some countries, are getting an easier way as opposed to others? I think if I think about the responses that I've given in the first instance to your initial comments, then that third question kind of becomes moot, because the way I'm thinking about the reconceptualized minimum core concept, there's no one who's getting a free pass, even the third world countries themselves. So that even if we go to a negotiating table and you have a country from the global north and a country from the global south, there's not going to be any sort of resentment or animosity from, let's say, countries in the global north thinking, oh, these guys are getting favorable treatment. Absolutely not, because it's not special and differential treatment in the sense of how special and differential treatment has been used in international law. It's a necessary flexibility device to allow for us to be able to interrogate the fact that different people with different levels of resources or different states with different levels of resources should have to account at different levels. So in that sort of way, it's kind of trying to even the playing field as opposed to putting someone on a pedestal or one country on a pedestal as compared to the other.
Okay. Sorry to cut in front of you. Thank you very much for the paper. I really enjoyed it. And I also had questions about indicators, but we've kind of talked about that a bit. But I was just curious what availability of resources might be interpreted as, given what you said in terms of who's resource rich and who's poor, and some of the relationships between public and private actors for exploiting resources, how that might play out on the sliding scale. And then another one was just a suggestion, which I thought at first it was really interesting, the debate about the relationship both between North and South states, and then also within states. And it's coming clear from the presentation, which I didn't get at first, that really this is the tool for folks to criticize their own states, and not necessarily, although potentially, something that could be a source of kind of collective organizing as between North-South states or states within the South. And that's something in the Twailing literature that's come out, especially over the generations, is maybe sort of being on behalf of states' interest versus non-state actors, NGOs, and those kind of things. So that might be something that helps, I don't know, highlight what you were saying about Professor Chimney, the pragmatic approach to this lens on minimum core, is to say this is what this tool is for this particular actor in this particular context. And it may also have other benefits apart from that. Sorry, that was a long comment.
Thank you. Did you want to say anything in response? Or?
Yeah, so thank you very much for the second comment, especially because, like I mentioned, the paper is still in draft phase, and I'm trying to think of ways to refine some of the arguments that I've actually made. I think for the question, the key question that we've actually raised in as far as availability of resources, so that's the crux of my paper, right? Like my whole the fact that you have resource differentials between states. So some states are resource rich, others are not, and because of that, they're dissimilarly placed, and therefore we can't have a universally applicable minimum core. Because if we purport to have this kind of a universally applicable minimum core in a situation where we have differently states placed, then rather differently placed states, then we're going to have a problem in terms of fairness and so on, at least from a TWIL perspective. So what I'm still trying to do is I'm trying to figure out exactly how to measure this availability of resources. So I'm trying to use indicators. I'm doing some research on various types of indicators that I could actually use for these particular purposes. But I think eventually, whichever indicator that I'll actually settle on will be one that enables me, at least from the perspective of prior arguments that I've already made, to be able to justify some of the points that have already been raised. The fact that if you have a country that has more resources, however we measure the amount of resources that they have, to be held to a higher standard of account. And tying back to the second comment that you've already mentioned, because you see, the point is, even within the global south or countries in the third world, there are resource differentials. So toilers don't just, or at least from my argument, it shouldn't just be us versus them. It should also be within the context of the third world. We're not trying to allow governments to get away with not meeting their obligations. And by having an analysis on the basis of resources, even amongst countries in the third world as compared to each other, then we can be able to hold everyone to account to the standard that is expected depending on what they actually have.
Hi. So earlier on, you spoke of the benefits and shortcomings of both the needs-based and value-based approaches to understanding the minimum core, and your two-tier model seems to use both. But would the first tier be focused on needs only? And if so, don't the same problems just carry over? Like, how minimal do we understand those needs to be, and how do we make sense of different societies' different understandings of what absolutely basic needs are?
Okay, so in the paper, what I do is I actually try to interrogate. So I use Catherine Young's work quite a bit in terms of offering counter arguments, but from a TWIL perspective, because Catherine Young actually talks about the different ways to think about the minimum core concept to give it content, and the normative essence approach is one that she mentions. So that from the needs-based approach, like I mentioned before, then the implication would be you think about what basic needs are, and then you ensure that or the argument becomes that if the basic needs are met, then potentially the minimum core, as far as that particular right is concerned, is actually going to be met as well. But I don't agree with the needs-based approach to giving the minimum core content, because as you've rightly pointed out, what's basic need or what a basic need is going to vary from point to point. So then even when I think about the absolute core in my sliding scale, I actually mentioned that the absolute core itself will not be comprised of the needs-based approach. Instead, we'll use indicators. Again, now the question becomes what indicators could potentially be used for purposes of saying that the right to food has been met, or the right to health has been met, maternal health, whatever. But you see, the committee already is actually making strides in as far as using indicators are actually concerned. And depending on which specific right you actually focus on, there are a number of indicators that could be useful to help to check whether satisfactory levels of the right are actually being enjoyed. So as opposed to just saying that, okay, if basic needs are met, generally speaking, then it would require an analysis of specific indicators, and then the indicators, once outlined, would apply evenly at the first level, and then subsequently, the second tier would operate to encourage dialogue in as far as additional resources are concerned.
Much, Caroline. My question is somehow a practical one, and it relates to the accountability of states with regard to some of these obligations that states generate, but they fail to implement, and the weakness in international law of an accountability deficit. And I think this is also one of the TWIL's critique, the weaknesses of a variety of international norms and standards So the first question would be, whatever standard you may use, whether it's an absolute standard or a sliding scale obligation, and even if you go to the traditional one, the progressive realization of these norms or these rights. And I'm talking about the problem of judicial accountability or judicial enforcement of these rights in the national context. Okay, how do you hold states accountable? How would you hold states accountable from a judicial point of view? I mean, given that these rights entail policy issues, these rights entail resource allocation. Okay, so even if states are committed to these rights, but there is a level of non-realization in the sense that quite a number of people, especially in the third world state where people are still deprived of basic necessities, water, electricity, roads, and so forth. How do the judiciary properly and practically enforce these rights? For example, where there's a finding in a typical human rights claim that the government is not meeting any of these standards. Okay, so first of all, there's the first level of a finding of a human rights deficit or a human rights violation by a government policy measure that does not meet any of these standards, whether it's progressive realization or the absolute standard. How would the judiciary enforce that human rights deficit in the case of a state in the domestic context? The next question, of course, is what would be the Twaile's contribution to these questions of social justice, owing to the accountability deficit of some of the international norms. I mean, if the problem, as you pointed out, Chimney says, the problem with Twaile scholars is that Twaile has failed to give pragmatic insights into international law, so that in the context of socio-economic rights, the urgency, I mean, what the people need in these countries is social justice. They need to realize social justice like yesterday. So how would Twaile, what would be Twaile's pragmatic insights into the realization of some of these social justice considerations? I don't think that's just it.
So the first concern about judicial enforcement in the national concept, I can neatly sidestep that question because the paper very clearly, like the scope when I initially drafted the paper was, I specifically excluded regional analysis of the minimum core, regional use, and also domestic use as well. So for this particular paper, I don't go into that. But I'm actually working on something else in as far as potential judicial enforcement of ESRs, and I use Kenya as my case study for purposes of trying to see, even if I do have this almost utopic idea of my minimum core and how I think it should or it could actually be implemented in practice, how would that trickle down by the time we get into a particular country, right? So that I'm a rights holder and I want to say that my government is not delivering on the promise of economic and social rights. They're not giving me the minimum core of, name it, whatever economic and social right is actually there. At the national level, I think dialogue, like constitutional dialogue or dialogic activism, would be a very useful tool in order to help domestic courts to have a better shot at ensuring that the minimum core of economic and social rights are actually achieved. And there's a lot of Kenyan jurisprudence that is coming out of the courts, because since 2010, when we got the constitution that has all of these ESRs, the courts have slowly been dealing with questions of economic and social rights in cases. And I have quite a number of cases that I'm looking at where the courts have come out strongly in favor of saying that even if it's a question of policy or it's a question of, these polycentric disputes that have so many ramifications, some courts have come out strongly to say that, no, we're not going to be afraid to give a decision here, even if the decision has policy ramifications. But what I'm doing now within the context of arguments for dialogic models is that a court, if the Kenyan courts are not so heavy-handed, in giving pronouncements and saying you need to do 1, 2, 3 in order to meet the minimum core of right 1, 2, 3, instead they have dialogue with other branches of government, then that might actually help to ensure that the rights become more than just mere intangible parchment rights and all that. And then your second question is, what's Twail's contribution to questions of social justice in cases of accountability deficit? Basically, how can Twail help to ensure that we have social justice? I think in a roundabout way, one of the things that I try to figure out in the research, and maybe later on after I write the paper, and even as I'm writing the paper, I try to step away and ask myself, so who benefits from the kind of analysis that I'm advocating for? Is it the government or is it the people? Because at the end of the day, economic and social rights is all about the right holders, right? So even from my Twail perspective, at first blush, it may feel as though, and I constantly have to keep trying to move away from this, it may feel as though I'm thinking about it from a very state-centric perspective, right? Like I want to benefit, the analysis is to benefit certain states, not really at the expense of others, but at the end of the day, I'm very concerned about the right holders in an attempt to try and ensure that the right holders have tangible, they can actually enjoy their rights. They're not just mere paper rights, aspirational, as has been in very many jurisdictions. So I think Twail helps in this regard in ensuring that we have social justice, because when you think about like Twail, and not from the them versus us perspective, but even using the example that I gave earlier on in the discussion, where I say that, okay, if you are to, for instance, adopt this sliding scale that I advocate for, and then in the second tier, you have countries, even in the global south, being forced to justify how they've actually used their resources within the context of enforcement of economic and social rights, it immediately becomes possible for rights holders to say that, but well, you have these resources, why didn't you use them in 1, 2, 3, 4 ways in order to ensure that these rights that are constitutionally protected are actually enjoyed by the individuals? So I think a Twail analysis would benefit not only the state within the context of this international law dialogue, but even the individuals in particular states who are suffering from deficiency as a result of what you've called accountability deficits.
Good afternoon. I really enjoyed your presentation. I feel like this question has perhaps been asked before in not so many words, but I think I just wanted to clarify very selfishly for myself, if I understand you. So you're the 2 tiers that you prescribe essentially argues, so the first tier is to keep the minimum core, and then the second part is to use indicators to verify, to see if, given the resources of the states, that they have actually met the minimum core concept.
So kind of, because so for both levels of the minimum core, actually indicators will play a very important role, because so how I see it, in the first instance, we have the non-derogable core. There's some things you have to do when it comes to right to food. You have to alleviate hunger. When it comes to right to health, you have to reduce maternal, mortality. When it comes to right to water, right to education, you have to do certain things.
Mm-hmm.
So then you'd use indicators that apply across the board to everyone. And then this will help you to assess whether, if we want maternal health brought down by 50%, you'll check to see which countries have been able to do that, which countries have not been able to do that, as a way of assessing whether they're meeting their minimum core obligations in as far as the right in question is actually concerned. And then in the second tier of obligations, I want to use indicators that will help us to assess the level of resources that a particular state has. So now these indicators, depending on which indicator we use initially, like I'd mentioned, I thought of using GDP. If you have 2 countries that have 2 different GDPs, one higher, one lower, then the onus is on the country with the higher GDP, as evidenced by the indicator, to justify additional action that they have taken in as far as particular rights under the covenant are actually concerned.
Okay, yeah, that's okay. I think my concern then would be, so I remember Zachary had asked, like, how minimum is the is the minimum, right? Giving that not just even within the global south, that there are countries whose resources vary, and also giving the problematic nature of also using GDP. I'm sure you're familiar with all of that. And so I think my question would be then, that isn't even the minimum, and this is something that you touched on during the talk, even the minimum core, isn't it problematic to keep it within the two-tier? Don't you see, do you envisage, contemplate running into conceptual or theoretical debates with that?
Absolutely. But I answer that by saying, I mean, perhaps somewhere in a sort of escapist fashion, that still, even if we have those conceptual difficulties after we reconceptualize the minimum core, from a TWIL perspective, at least the new minimum core would be better than how it's currently implemented, because there's a lot more flexibility for purposes of assessing whether states are meeting additional obligations depending on the resources that they have. But yes, I think the minimum core is inherently problematic. So even having it in my solution is problematic, but I still can't see a way around it. When I get a breakthrough, I'll let you know.
How many this time? 4? Oh, sorry.
I think your paper has helped me, like, sparked a light bulb in my head. So I'm constantly thinking and wondering, why didn't I even criticize the minimum core concept all this while? But I'm thinking about the obligation of conduct and the obligation of result. I find like states in the global north can definitely walk away from, okay, obligations of result, but not obligations of conduct, especially if we include that obligation of conduct to also be about the obligation to the third world, which is why I asked. And when you mentioned that sometimes some of the resources located in the global north are actually resources that belong to the global south, you know, due to globalization and the deterritorialization of these resources that move to the north, would it be opposite to posit that these states, if we can focus a lot from a total perspective on the obligations of conduct for these northern states, not to just say, well, you know, we've beat the minimum core, but what exactly are you doing constantly and how broad? I don't know if your paper looked at that. Did it?
It's like you actually read my paper, because that's exactly what I say. Like in the final analysis, the argument that I make is that we need to emphasize obligations of conduct more than the obligations of result, because inherent in the obligations of conduct is going to be dialogue about what we are doing in as far as the resources we have, where the resources came from, and so on and so forth. So when I make the analysis of the minimum core as obligations, I actually advocate for something that Young doesn't in her paper. I say that the committee currently, of course, they've said time and time again that within the context of economic and social rights, they're concerned about both obligations of conduct and of result. But I argue that from a TWIL perspective, focusing on obligations of conduct might be more useful, because it will ensure that we have a wider scope for assessment of obligations.
Then just my final point, sorry. When we talk about a value-based, like you said, needs-based analysis versus values-based analysis, and we talk about, you focus on human dignity, do you think there will be a conflict since we're using indicators that have to do with numbers? So like GDP, for example, the budget, how do we gauge human dignity? The reason why I ask is, for example, the Committee on Economic, Social and Cultural Rights will say that Nigeria is sort of lagging behind in fulfilling its obligation to these rights. Meanwhile, we'll read indicators who will say Nigeria is the happiest country in the world. And how do we marry that? I know sometimes the committee will go very in-depth by saying the right to housing should include like a nice, good space with heating and all that. I think my own conflict here is by saying that even if these states have complied, like northern states have complied with the minimum core obligations and everything, how come, if you look at like the Global Happiness Index, how come such third world states that are lacking behind are ranked very high on things like happiness, especially if you say things like food, water, healthcare are things that can actually make you happier otherwise.
Yeah.
I don't know if I'm moving too far from...
No, I get your question, but I guess at the end of the day, and the big question really is which indicators are we going to focus on? Because there are all sorts of indicators out there, and I think initially I mentioned it's a minefield that I'm currently trying to navigate through. So I'm very careful about the kind of indicators that I'm suggesting. I'm specifically avoiding things like the happiness index for the very reason that you've actually pointed out, because they kind of tilt my entire analysis and make me question some of the fundamentals that I've identified.
Collecting their thoughts, let me just sneak in something. A question of my own. So I was just, sort of listening to your talk and thinking about it, and I was wondering, okay, so if it has all those problems, why are you still for it? Minimum core, that is, right? So why, so in Grootboom, which is a case from the Constitutional Court of South Africa, the Constitutional Court, this was early in the day, of South Africa. As you know, South Africa has one of the few constitutionally justiciable set of economic and social rights provisions, and has the most developed domestic jurisprudence in that area. But anyway, in that early case on economic and social rights in Grootboom, the court said, no, we're not going to follow the Committee on Economic and Social Rights, Social and Cultural Rights conception of the minimum core, precise for many of the reasons that you offer, right? And they said instead, we're going to offer an alternative concept that better addresses the peculiar situation of South Africa, right? As a global South country, its own experience, a country riven by poverty, class inequality, and all that. And part of that reason was they wanted flexibility, right? Which is one of the things you're aiming for. And they said, let's use a reasonableness standard. So we place an onus on the executive to present to us its plan for redressing these ongoing violations of economic and social rights, right? Whatever. In Grootboom, it was the right to housing, right? In Subramuni, it was right to health, in particular kidney dialysis. All kinds of economic and social rights. So the government has to come and justify and say, look at what we're doing, right? And the court can say, based on the kind of administrative, I don't know whether people have done administrative law, notion of reasonableness, whether this is reasonable, without necessarily telling the government, which is elected, and of course there are critiques of a democracy deficit and of an elected judges and all that, but wherever you stand on that, in that sort of debate, it seems to me that might do the work that you want to do. I don't know, so I'm just asking. So is there a reason not to simply globalize Grootboom? Or is it because we don't globalize things from the global South? Why?
Okay. Thank you very much, Prof, for that question. I still think the minimum core concept is useful. Like, I critique it, and I deliberately, from the very beginning, I say I accept that the concept is problematic. It's it's ambiguous. It's plagued by paradox and all that, but it's still useful, because my fear is that if we do away with the minimum core concept, and coming from the kind of country that I come from, where the government is forever looking for any loophole to evade obligations, if we do away with the minimum core concept and say that, okay, economic and social rights, achieve them progressively, then I think the rights holders might as well, just forget about this particular economic and social rights. So I think the concept, despite its difficulty, the normative difficulties that we experience, is still useful. What we need to do is think about how to give the concept more content, like to make it more useful in practical application. And in fact, in another paper, in this paper, I don't go at all into, South African court arguments on the minimum core. I mentioned in passing that, the South African court actually explicitly rejected the minimum core concept. They said that, they don't have the kind of resources the CSCR has to make these kinds of analysis, so they're not going to use the minimum core concept, and they instead decide to use reasonableness. In another paper, I make an argument for a merger of the minimum core and reasonableness standard, and I say that perhaps we need to move away from either one or the other and use what I call the minimum core of reasonableness, so that you basically have a situation where if the government wants to say potentially that, so it would play out in a national context, let's say like in a domestic court, that if you have an ESCR issue, someone has gone to court, a rights holder, they're saying that, my right to food has been infringed upon, or my right to housing, or my right to education, whatever right is actually in question, what the court would actually do is that they'd ask the government in that particular context to justify their actions, right, in as far as the right in question is actually concerned. But then the justification, the reasonableness argument would then be untethered, in the sense that you'd still need to have a sort of bottom line, right? So that the government is expected to deliver this. So tell us why you didn't deliver. So we start from somewhere. So then it's the minimum core of reasonableness, because if your explanation is reasonable, even as to why you didn't deliver on the very basic, then you could actually get away with not being in violation. But if it's not, then the court can step in and say absolutely yes. So I think it's possible, and perhaps it would be very, very useful to merge the two concepts of minimum core and reasonableness. But I don't know how it would play out in the international sphere. In the domestic sphere, I see it happening.
So I'm so sorry that I missed the first half of your talk. I was teaching, but it's all been, so this might be completely random and off base, but I just have this a sort of a very broad-based concern about the amenability of social and economic justice concerns to classic individualist, liberal, and now neoliberal rights language itself. So I'm wondering if achieving, so in other words, right, economic and social rights are different from, this is a well-known narrative, right, civil and political rights, which tend to be attached to the individual as citizen right bearer against the state, right? Whereas if we're talking about more emancipatory government frameworks based potentially in something like a democratic socialism, we see economic and social rights as collective goods that are at odds really with the modalities through which individual civil and political rights are achieved. So I'm just wondering, and I think this is just sort of riffing off Professor Okafor's question, right? Where if the attachment to the core substance I totally am on board with, it's more, is there a way of operationalizing that doesn't fall into some of the common traps that individualistic rights-based language tends to? In other words, it might just be an oxymoron to say that economic and social justice can be conceived of as rights. Does that make sense?
Kind of. Yes. I'm not sure how to respond to that, but I mean, picking up on something that you mentioned, that sometimes economic and social rights will be at odds with how civil and political rights are achieved. I don't think that may necessarily be the case, because
abandon the language of rights and still be really robust and substantive concept of collectively based economic and social justice. So you can be committed to a concept, but not the framework of the right.
Of rights, which is true, and I've had that argument before, but I feel like the language of rights is important, and especially in the third world, because it empowers the rights holders to even be able to conceptualize the rights that they actually have. Because, for instance, within the Kenyan context before 2010, we didn't have economic and social rights, right? Because our old constitution didn't have anything like that. But now with the constitution that very clearly and elaborately sets out economic and social rights, concepts of social justice, which before may have been difficult to frame within the context of a national court, are now very easy. The Constitution has empowered people to actually say, this is a right that I actually have. So to that extent, I think the language of rights retains some utility. Okay. Mm-hmm.
The benefit of using a rights discourse is that it translates needs into entitlements and and what would otherwise be charity into legal obligations. So I think it's also empowering in that way. Otherwise, it's left up to the goodwill of those who have to provide for the vulnerable.
Yeah, thank you. That was a very good paper. But I just wanted to share my experience in relation to some of the issues that have just been raised. I recall when I did the Kansaro Wiwa case before the Oputa panel, and the challenge I had was to prove that his killing was unlawful. And he had been killed based on a tribunal that was set up under the law. The tribunal convicted him, and he was hanged with his, associates. And then under the domestic law, we couldn't pursue the case, as it were. But when the Oputa panel was set up, and I went before the panel and I wanted to make this argument, they said, "Oh, but we complied with the law." There was a law, and he was convicted by the tribunal, and then he was killed. It was very difficult. I had to go to the Covenant on Political and Economic Rights, and I found that there was a clause which said that you couldn't convict somebody and sentence the person to death except there's an appellate process in the domestic system. And so I said, well, they had breached that right, that provision. And they said, oh, well, yes, the tribunal convicted him, and we sent it to the Armed Forces Ruling Council for ratification, and they ratified it. And I said, well, that wasn't an appeal process. They didn't have a right, and blah, blah, blah. And the panel agreed. And that then led, because of course it was just a sort of like a reconciliation panel, and they agreed that there had been a violation, even though Nigeria did not actually sign that portion of the covenant. They didn't sign that portion, but the panel agreed, and then made a recommendation to the government that led to the reconciliation that took place between the Ogoni people and the federal government. So I think the point is that it would have been extremely difficult for me if there was nothing to hold on to, in terms of rights or some expression of some entitlement. It would have been very difficult. So it's difficult to I see the point that has been made about these issues not really being strict rights as such. And I knew it wasn't a strict right, but I made the argument, and I was able to get some solution to that family and their entire people. But I would have preferred if it was better expressed.
Thank you.
Any other question?
Thank you so very much. I'm just trying to take it back to a question that Professor Bhatia had tried to raise about the resource, the resource-rich country. I always have some misgivings. I don't know if I'm just the problem. When you talk about resource, where do you place the people? Countries like Finland didn't have the kind of natural resources that some countries have, and they realized that a knowledge-based approach would actually get them out of the doldrums. So they invested whatever they had in people. So when you talk about this issue of resource-based or resource-rich in determining the elements of the core minimum, where do you place the human beings? What are there in those resources? Is it the gold? Is it the amount of money in the banks? What are the resources?
Okay. So what do resources mean? I think the word resources could mean different things to different people. Within the context of this particular analysis, I guess that question would be answered by the choice of the indicator, right? Because whichever indicator I end up using would actually map the particular resources that, you know, we're analyzing for purposes of arguing that a particular state that is resource rich according to the indicator in question can be considered to have additional obligations, which is a neat way of saying that I'm not sure because I haven't figured out the indicator that I'm going to use. But I take your point.
The last comment I would add on to what Prophet said, that the reasonableness standard actually can realize the minimum core duty, because the reasonableness standards in the national context, first of all, gives a great deal of leverage and judicial discretion to the person who is assessing the government's accomplishment of some of these duties and obligations, as opposed to the minimum core, whose criteria is yet to be decided, whose criteria is yet to be concretized. The reasonable standard is somehow broad and gives a great deal of leverage of discretion and actually has got no minimum threshold. If you take into the national context where some of these claims are being exercised in a practical world scenario, I mean, people who do not have houses are coming before the court and they're insisting on the realization of these rights. They're insisting that the government fulfill these obligations. It takes up to a practical context where claims that have been has been recognized in the international context or international law are now being pursued by people in real life situations. In that kind of an arrangement, insistence on minimum standards would not practically work unless and until you give the judicial officers or institutions that are assessing these standards a great deal of leverage, a great deal of freedom to assess the situation obtaining at the time and to prefer or to craft practical remedies that can realize social justice. I mean, people who need water, people who are dying of HIV and AIDS, you know, and the government is not providing some of these services. In such kind of an arrangement, until and unless you give some sort of an undefined and unrestricted standard, then you'll not be able to achieve much. So in my view, I think I would join Prof. Some of these countries who have come up with the reasonable standards. South Africa and Kenya is actually one of them because we have been following that jurisprudence from South Africa.
Okay.
Thank you so much.
I just, let me have the final word, kindly. Reasonableness has also been criticized on various grounds, and I always have a problem with a pure reasonableness argument within the context of ESR enforcement, because I feel like reasonableness can sometimes be unduly differential. Like if the judiciary adopts reasonableness without some sort of caution, let me say, they could end up being unduly differential to what the legislature or the executive is actually doing in as far as rights enforcement is concerned, which is why I argue for both the minimum core and reasonableness, right? Because if we combine the minimum core and reasonableness and use the tool like dialogue, for instance, to allow the two, you know, the judiciary as well as the executive to actually negotiate on the value of rights, then chances are more likely that the rights will become enforceable in practice. Because I feel like if we don't have this kind of dialogue and the court, uses minimum core only, then of course there's no political will to implement. Or if they use the reasonableness standard only, then they're unduly differential and the executive or the legislature has too much wiggle room, then we'd still end up with the same problem in as far as the rights holders being able to enjoy the rights. Because as several people have mentioned, and as Zachary mentioned just a few minutes ago, in all of these discussions, we cannot lose sight of the fact that our concern is always with the rights holders, period. So everything that I'm trying to do here, even from a TWAIL analysis, it boils down to, will the rights holders be better off by this kind of analysis? Because if the answer is no, then we're not really doing what we ought to be doing.
With that last word, we've come to the end of this edition of International Law in the Global South. We hope you come to the next one. All that remains for me is to present. We have a beautiful work of art that we want to present to the guest speaker so she can take it to Nairobi and boast to all our friends that she came to this great school called Osgoode. Let's give her another round of applause. Thank you.